115 talks about scientific advisors. Often we have this apprehension how the courts of law, which are largely manned by judges who are not trained in the science, how is that they can decide disputes where there could be issues of scientific facts involved. Now, scientific advisors is the answer to that problem. 115.1 states that in any suit for infringement or any proceeding before a court under this act, which includes declaratory suits under 105 and 106, which includes suits pertaining to ownership. There are provisions where the co-owners can approach a court of law to finally determine matters pertaining to ownership of patents. In any of those proceedings, the court may at any time, whether or not an application has been made by any party for that purpose, which means the court can on its own, what we say suo motu, do this, or on an application made by the parties, appoint an independent scientific advisor. So, the scientific advisor has to be an independent advisor if the scientific advisor is appointed under 115. Parties are free to bring their own party advisors or party expert witnesses from their side, but 115 pertains to an independent scientific advisor to assist the court. So, the role of the scientific advisor is to assist the court. So, this solves the issue in some way with regard to how will the court look into scientific facts which may not be within the realm of their knowledge or expertise. To assist the court and to inquire and report upon any such question of fact or of opinion not involving a question of interpretation or law as it may formulate for that purpose. So, the assistance that the court gets is or will pertain to a question of fact or of an opinion which does not involve a question or interpretation of law. So, the questions of law and interpretations of law are out of the purview of the task assigned to a scientific advisor. So, the scientific advisors will advise on scientific facts and give opinion based on their technical expertise. Now, again it is the task of the court to formulate the question on which it requires assistance. So, if there is a disputed fact and courts are equipped or the legal process is equipped to determine issues of fact, if there is an issue of fact and there are two conflicting opinions from either side, the court may appoint a scientific advisor to give his opinion on that question of fact. So, the court has to formulate the question. The scientific advisor should not be allowed to give an opinion on the case itself. That is not the objective of appointing a scientific advisor. A scientific advisor, since his job is to assist the court or to inquire and report upon a question of fact, the question of fact should be formulated by the court and communicated to the scientific advisor. 115.2 states that the remuneration of the scientific advisor shall be fixed by the court and shall include the cost of making the report and a proper daily fee for any day on which the scientific advisor may be required to attend before the court, and such remuneration shall be defrayed out of the monies provided by the parliament by law for the purpose. So, the scientific advisor, because he has to be an independent person, is largely taken from the role of scientific advisors, which is maintained by the patent office. Now, we will soon look at that role. So, it largely comprises of people who are in some form of government service and who have expert knowledge in a particular field. Rule 103 tells us that there is a role of scientific advisors which is maintained by the controller, and the role shall be updated annually. The role shall contain name, address, specimen signatures and photographs, their designation, information relating to educational qualification, the disciplines of their specialization and their technical, practical and research experience. So, it is an exhaustive list. So, it becomes easy for the court to identify a scientific advisor based on this role that is kept by the controller. Now, a person who is qualified to have his name entered into the roll, if he holds a degree in science, engineering, technology or equivalent, has at least 15 years of technical, practical and research experience and holds or has held a responsible post in the scientific or technical department of the central or state government or in any organization. So, this is the requirement. The person should have been in service with the central government, state government or any organization, and the person should have sufficient knowledge and expertise and even research experience in the field. Now 103A talks about certain disqualifications. What if they are entered, or a person's name should not be entered into the roll if the person has the following disqualifications: he has been adjudged by a competent court to be of unsound mind, is an undischarged insolvent, which means he is bankrupt and he has dues, being a discharged insolvent, has not obtained from the court a certificate to that effect, that is insolvency was caused by misfortune without any misconduct on his part. So, if he was a discharged insolvent, then he should get a certificate showing from the court saying that his insolvency was not because of his conduct, and if he has not done that, then he is not eligible to be a scientific advisor. Has been convicted by a competent court, whether within or outside India, for an offence to undergo a term of imprisonment unless the offence for which he has been convicted has been pardoned, or unless on an application made by him the central government has by an order removed the disability, or he has been guilty of professional misconduct. Some of them are moral issues. So, if a person has any of these disabilities, the person will not be entitled to be included in the role of scientific advisors. 104 details the manner of making applications for the inclusion. Any person may apply to the controller and furnish the biodata. Rule 105. Now, the controller may enter the name of a person in the role of scientific advisors if he is of the opinion after such inquiry that such person should be entered. So, even if a person does not apply to the controller can include names if the controller feels that such persons could act as scientific advisors in assisting the courts. Power to relax, where the controller is of the opinion that it is necessary or expedient to do so, he may by order for reasons recorded in writing relax any of the qualifications mentioned in sub rule 2 of rule 103 with respect to any person. So, if there are not enough scientific advisors on a particular field of technology, the controller has the power to relax the requirements. And there is also a procedure for removal of names of the scientific advisors from the roll. Now, the controller can remove if a person makes a request for such removal, or if the controller is satisfied that the name was entered on account of a misrepresentation or suppression of material fact, or such person has been convicted for an offence and sentenced to a term of imprisonment. So, he is convicted for a criminal offence or has been guilty of misconduct in his professional capacity, and the controller is of the opinion that his name should be removed from the roll, or such person is dead. So, these are the conditions on which a person's name can be removed.